Hello and welcome, and thank you so much for joining us today for this Concurrence Antitrust podcast. Now, I'm delighted to welcome today to talk to us about mergers in digital, Alden Abbott from the Federal Trade Commission. Thank you so much for being here. First of
Well,
all, tell us a bit about your work, what you're doing, and a bit about yourself and how it intersects with our subject matter and why it's important.
thank you, Jennifer. Actually, I was uh, for several years. I'm former general counsel of the Federal Trade Commission, and in that regard, I obviously interacted a lot on the staff that dealt with mergers, enforcement actions in courts, and so forth, as a chief advisor to the members of the commission. Now, currently, I'm at the Mercatus Center at George Mason University, directing a research program on competition policy. And that's a research center with the lawyers and economists. I organize conferences on various aspects of competition policy and anticipate, having dealt with mergers in a professional career in competition law, both at the Federal Trade Commission in different roles and in private practice and in the Justice Department. I anticipate, as new proposals, for example, new guidelines on mergers are released, to be holding conferences and writing articles on that topic. And this is a time of great interest because, indeed, as I mentioned, the leadership of the American competition agencies have announced plans to issue new merger guidelines, which makes the consideration of how they will treat digital mergers in particular of great interest.
Well, let me first start by zooming in on the digital part of our discussion. What is it that makes the digital sector different from other sectors? Can you pinpoint anything that you've seen as an emerging merger antitrust concern or competition concern that is very unique to this area?
Right. Well, the general concern about so-called digital mergers generally involves platforms which have a great major online preference or presence. Obviously, one thinks of Google, Amazon through its sales, Facebook, Twitter, but also companies that, so-called closed gardens such as Apple, which have their own app stores, which interact with the internet through that. And the concern in that case is you have these very large platforms. And the theory is that these platforms may, by buying up complementary assets, by that I mean companies where they are not currently doing business. For example, proposals by Meta, formerly Facebook, to acquire Within, which makes virtual reality products. The concern is that these firms will use complementary assets, things that their online users are interested in using to entrench their dominance, to gain extra monopoly power. And the argument is this is different because in conventional mergers, say in product markets, you're concerned about people selling the same or products or close substitutes, or in vertical mergers, firms that can go upstream or downstream to deny input to competitors. Here, the concern is more vague and inchoate. It's saying this is a huge firm. Any merger it makes of a company that provides some online services could, in effect, later be used to entrench its power. That's the whole theory. Really dates back to the Microsoft case of late 1990s in the United States, in which it was argued that that Microsoft was trying to kill a competing browser in order to maintain its monopoly in Windows operating system for desktop services. The complaint was about an acquisition. Their complaint is they're trying to use their Explorer browser to prevent any new browsers from emerging because it's a threat to their monopoly. Here, the claim is that companies like Google or Facebook are buying up companies that otherwise would compete and perhaps might use some of their assets to become major threats to the dominant platform. That is the theory in any event.
Well, one thing we've seen here in Europe that's been difficult when it comes to working out competition on dominance is definition of the market sector, because one of the counter arguments you will often hear from the platforms in the digital space is that, well, actually there are competitors. You can go shop elsewhere if you're Amazon, or Google will say, well, we're not a shopping platform, we are doing advertising. And I think, I mean, even to break it down to something like Uber, who say we're not a taxi service, we're a platform. Definitions of the market sector seem to be causing causing customers confusion, but also causing the enforcement agencies confusion here. Are you seeing anything like that?
I think that's right. In fact, the Facebook now made a case brought by the Federal Trade Commission. At first, the judge raised questions about market definition. The commission justified their social networking market because the judge said, in fact, what is a social networking market? I mean, you can it's not as clear as certainly the market for steel bars or the market for tires or small automobiles. That's very tangible. But the idea was, what if other platforms can offer services of various sorts? They may offer social services. Or are you saying that those are all included in the market, even if they're not currently in the market? So it does create confusion. Now, I think some of the defenders of the platforms will also say, well, wait a second. Where's the consumer welfare has been the central concern of certainly American antitrust, and to some extent European antitrust for decades now. Where's the evidence that consumers are being harmed? They're being given new services. Think of Instagram and WhatsApp. Those were acquisitions by Facebook, which are being challenged by the Federal Trade Commission. And yet the argument is, well, the platform was able to bring these applications, photo sharing and messaging up to scale faster to benefit more consumers faster. And how do we know, if left on their own, that these companies would have provided services nearly as good to consumers? And indeed, a second question is that if you start preventing platforms from acquiring sort of complementary assets like these, as I say, Instagram and WhatsApp, venture capitalists may stop investing in them. They say, because some of these companies may be developed with a hope of being acquired someday. And if the enforcers are saying we're not going to allow such acquisitions, you may get fewer startups and less innovation from that side. So it's all a very, very complicated picture compared to traditional market analysis. As I said, of course, the agencies will say, well, no, you have network effects. This firm is dominant. If it keeps buying up these complementary assets and cyberspace used by its customers, it's going to continue to be dominant. And we don't like continued dominance. We want more competitors.
Well, I want to talk about data with regards to mergers. And let me pick up then on a case you mentioned, one of those acquisitions of Facebook by WhatsApp. Now, here in the EU, certain conditions were put on the approval of that because there was concern that data merging of the consumers could hurt them, it could lead to profiling and so on. What's your take on that? What's your position?
Well, look, the problem of imposing conditions in traditional vertical mergers, you might say, well, you're buying a firm that provides inputs. It has dealt with your other suppliers that may know some of their trade secrets or special information. You shouldn't be able to disadvantage them after the merger by having that information. That's a sort of an understandable concern. It's less clear to me what the particular concerns you're looking at. A lot now turns along on privacy issues. Of course, in Europe, you have a GDPR privacy law, and there's a great concern about what the platforms are going to do. How should platforms be allowed not just to use consumer information, but even if consumers give full consent on an opt-in basis? There's some who say, like Lena Khan, the head of the FTC, that maybe that's not enough. Maybe certain types of information should never be provided, because the more information they get, the more they'll be able to control their market. And again, is somehow bad. But again, there are two sides to the information issue, because using this information may allow um, a platform to provide new services that are attuned to the interest of particular consumers. And those new benefits consumers may accept, but they don't necessarily know where the benefits came from. They just know there are new, more and more features on the platform. So by putting any limitations, including privacy related or other limitations, and on platforms, are going to prevent them from providing new and better services.
Well, I think you're hitting at a point there that there are some fundamental differences between the US and the EU in how we approach some of these things. In the EU, we of course now have the new Digital Services Act, the Digital Markets Act, all of these other sort of, if you like, tangential to competition law rules that we're seeing. How do you view them from across the Atlantic? Do you think there are lessons to be learned from Europe? Do you think Europe is in the right direction on this? Or where do you see it all fitting internationally?
Well, certainly, for example, we mentioned Digital Services Act. There's also the Digital Markets Act, which is being implemented over the next couple of years, which in effect, in many situations, will sort of mandate interoperability and sharing of data, across platforms. Of course, some of those may be intentional, the privacy goals of the GDPR. There's some who argue, are those things intention? It's not clear to me. My concern is what Digital Markets Act, the idea is creating all this interoperability. You're going to have more platforms. You're going to make Europe the digital leader by 2030 is a theory, but then there are critics like, oh yeah, Paul Therese of the Information Technology and Innovation Foundation says, look, this is a form of precautionary antitrust. It's in effect is to prevent lots of acquisitions. And if you really want the best platforms, Europe has up to now has not provided leading platforms. In general, most of those have come from the US. And one of the reasons has been what one author, Adam Thier, my current colleague at Mercatus Center, calls permissionless innovation. It's easier really to establish platforms in the US. And it may be a great idea to say, well, you want interoperability, but they're major costs. The platform, in effect, is required to interoperate. It's going to have to re-engineer its systems. It's going to have to change the nature of its algorithms. And again, it may seem nice on one level, well, we're going to have more competitors, but are you really, and are those competitors going to be providing something that consumers want? If they don't, those sorts of costs are probably not worthwhile. US is looking at some proposals like that, some antitrust legislation that's hasn't gone to the floor of the Senate yet. There's some dealing with app stores, others dealing with acquisitions by dominant platforms, interoperability. So I think certainly the leadership in the US antitrust agencies, more than ever before, is very and has said so publicly, is attracted to the ideas underlying the Digital Markets Act. I would wait. I'd say, let's wait to see what the effects of the Digital Markets Act are. If they're creating new and successful platforms and all sorts of innovations, great. But if they're not, then it's not a smart idea to pass legislation. So I would be cautious. I'd say there is, and this is underreported, but for instance, Professor Brynjolfsson, formerly of MIT, now at Stanford, wrote an article in the December 2019 Harvard Business Review about the benefits not counted in GDP statistics given to consumers by platforms. He did some sort of experimental economics and suggested that, on an annual basis, hundreds of billions of dollars, or say euros, in benefits are being showered upon consumers, which are not actually reflected in the profits. That's above and beyond the profits and the advertising revenue and so on that the platforms earn. So I would be very cautious before legislating in the US.
Well, that's a clear note there, as we often see. It's legislate at your pleasure and then litigate at your peril. And we find that many of the laws that have been passed end up being tested through the courts, and some of them don't stand up. With that in mind, that's a frustrating way for businesses to have to deal with new laws and new antitrust or consumer or competition or indeed even privacy regulation. Do you see any cases coming up that you think we should look out for? Is there any litmus tests that you see in the coming years or months that might be a good sort of weather vane for the direction of travel?
Well, and in the I'll mention the United States because I always follow more closely. The FTC filed a complaint against Within United, which is a maker of virtual reality exercising apps. And what's interesting is this maker of apps, it was reported in trade press, and I don't know one or the other, that the staff opposed the challenge, but that the commissioners overrode it. We'll see. But basically, it's that the Meta, formerly Facebook, is not currently in the market of making these apps. And the complaint was, well, they were likely to enter, and therefore entry was squelched by this acquisition. And what some critics have said, there was an article in the Wall Street Journal recently, Lena Khan's Merger Metaverse, that said, wait a second, this is in effect based presumably on a nascent competition theory. This producer of apps maybe will allow, presumably, I think the big theory is that, again, to allow Meta to entrench its market power by becoming dominant in one more complementary area. But again, where is there evidence of consumer harm? Where is there evidence that there were other platforms and other could not have entered, not very difficult to enter? So I think it'll be interesting to see how do the courts, American courts, struggle with the idea, as you mentioned earlier on, what is the market? Have you defined a market? Is it too narrow a market? Is this talking about the market, for example, for physical fitness or training exercise apps? It seems very narrow because those are akin to electronic games or provisions that could be provided by all sorts of people, all sorts of software developers. I think in Europe, all I can say, again, I'm not a European lawyer, although I try to study what goes on there. But for instance, in the recent Intel and Qualcomm cases, the European General Court has, I think, suggested that the European Commission needs to have evidentiary basis and needs to be careful, in bringing bringing competition cases if they and needs as a due process matter to fully apprise companies of any changes in their theory of the case. So to me, what that illustrates is that even in Europe, the general courts are going to be, general court and maybe court of justice are going to be a possible constraint on the European Commission, just as in the US, for all these new cases being brought that seem interesting, that are non-traditional, the US courts, Supreme Court still says, until it changes, a consumer welfare standard is the American antitrust standard. Chair Khan has talked about harm to competitors, harm to labor, the anti-discrimination harms, income redistribution, all may be fine things, but traditionally, certainly American antitrust has not spent much time looking at those issues. So I think it'll be very interesting to see if the courts are willing to go beyond a consumer welfare standard in the US. And if they're not, I'd say that probabilities of success of some of these new cases in the US may not be terribly high.
Well, I think that's a really good place to sort of ask you to sum up, if you like, for our audience as a final question. What do you expect going forward? We've talked about what the courts may or may not do. How will that trickle down in practice to maybe how mergers take place? Will there be more caution, do you think, or will the C-suite be looking at mergers in a different way? And ultimately, how will that impact consumers, or will it at all?
Yeah. Well, I suspect in the near term, there will be a more caution by businesses because it's clear that the FTC is looking at a wide rather not giving routine clearances to the sorts of mergers it would have routinely cleared in the past when it was in a lot of direct competition or serious vertical series. There are going to be new merger guidelines, it seems, in the next few months. And if I would not be surprised to see the guidelines raise concerns about acquisitions by platforms. So I think there will be a lot of caution in deal making, certainly by the big platforms. May not affect other sorts of deals, but until court decisions start being handed down, going one way or another, that I think it might slow the incentives of the big platforms to make some of these complementary acquisitions. I don't know to what effect it will trickle down on venture capital and investing in sort of these new purveyors of new services, but that's possible as well. So I think uh, that's going to be in the short run. Long run, we can't, we can't tell. As John Maynard Keynes famously said, that everyone was dead in the long run. But in all seriousness, I think it's a period of caution. And if you're advising large platforms, you're going to advise them about these new theories and concerns about buying complementary assets and maybe be careful because even if the agencies don't ultimately win, there's litigation, there are public filings before the securities agencies, and those are real costs on business. And to the extent it slows down innovation in platforms, there'll be costs on consumers as well, in my opinion.
Well, I think predicting the long one is difficult, and of course, the long one in digital is not the same as the long one in other industries. It's you talked earlier about being worried about Microsoft Explorer dominance, and we look around now and we see, yes, it's a very different fear that we have today than we perhaps had then. Thank you very much, Alden, for sharing your great insight and experience with us. Thank you to you, the audience, for joining us. But do stay tuned. Keep an eye out for more Concurrence, your antitrust podcast.
Thank you, Jennifer, for hosting the program.